This is courtroom 1. This is the beginning of the first session for Monday, June the 24th, 2019. Judge Kirkland presiding. And this is I'm representing the State Attorney's Office.
Kafi Kennedy Swanson.
Representing the Office of the Public Defender. And the first case that's to be heard is a move-up from the second session. It is State of Florida, it's Miles Christopher Pennant, and it's in Division 10. And making a verbal notice of appearance at this time is?
Spencer Rhodes.
Thank you. And there are 3 charges here on this charging affidavit from earlier today. Burglary of a structure, criminal mischief, and trespassing. And it's a narrative that refers to late last night.
Your Honor.
Was the arrest. It's a warrant, and the warrant refers to May the 15th. So it is from a month ago, and the bond listed on the warrant is $4,750, no return to the scene and no conduct. And I understand that an agreement has been reached with regard to this case.
Yes, Your Honor. I spoke to Mr. Rhodes prior to court starting. We will have no objection to taking no action on the out on bond cases. And in order to do so, to double the bonds on the current case, so instead of it being $3,500 as to count 1, that it be $7,000 as to count 1, $2,000 as to count 2, and $500 as to count 3. No return to the school grounds. So we just doubled the bonds on the warrant.
And we do stipulate, Judge, and I waive Mr. Pennant's appearance.
All right. At this time, then, the court takes no action on the prior cases that are shown here, those being 2019 CF 6992 and 2019 CF 5642, and the hold that the jail has holding Miles Pennant is removed at this time.
And Your Honor, just for the record, the state has not made a charging decision in those cases, and that's the reason so we're not asking for the bond to be revoked, as we've not filed formal charges.
Very good. The warrant bond now, count 1, burglary of a structure, is $7,000. Count 2, criminal mischief bond, $2,000. Count 3, trespass on school grounds or facility, $500 bonds for a total of $9,500. Division 10.
Thank you, Judge. Bon voyage.
Thank you.
No problem.
We'll go back and recess until we're ready to go with the first appearances. We're ready to proceed now with the first session. These are first appearances, and the first person to be reviewed is Travis Richard Grubbs. And he does have, okay. This is Travis Richard Grubbs. I'm Judge Kirkland. I'm reviewing your case. It is an arrest from yesterday.
No.
In Orange County at East 8th Street and South Park Avenue. Count 1, battery on a law enforcement officer. The bond is $2,500. Count 2, resisting with violence, a felony charge having a bond of $1,000. That bond today is now changed for 1 and 2, and I'll come back to that. And then burglary of a structure has a bond of $3,500, and the 4th charge is criminal mischief. The bond on count 1 now is $150. On count 2 is a bond of $150, and count 3 will be a bond of $100. The total bond is $3,900. The public defender is appointed to represent Mr. Grubbs in Division 22. The case number is 19 CF 9021. There is an additional condition to have no contact with anyone that's named or referred to in the narrative of the charge and affidavit, arrest affidavit, and no return to 139 East 15th Street while the case is pending.
Yes, sir. Yes, sir.
It indicates that that's an apartment complex, and it would be not to go on to the
Yes, sir.
apartment complex, any portion of the apartment complex while this case is pending. You do
Yes,
have,
sir.
you do have the public defender.
Yes, sir, but I wanted,
Talk to your attorney right now before you say anything on the record. William Marcus Young.
He refused, Your Honor.
All right. This is a case that often can be resolved at first appearances, so I will reschedule for tomorrow to see if William Marcus Young Jr. decides to come see me for a first appearance. Otherwise, he can bond out. His bond is $250 as probable cause of holding on a city ordinance violation of disorderly conduct. David Keith Harvey.
He also refused.
Your Honor, we'd ask this case not get rolled. He refused to, on 6/21.
All right. I do see that he did refuse to appear before Judge Freeman on Friday. So at this time, no further actions taken up with regard to Mr. Harvey. He can bond out, and at his arraignment, he can request a public defender if he changes his mind. Molly Hunt.
Yes, Your Honor.
This is a charge of child abuse. It's a felony charge. It arises from
Not guilty.
2297 Gator Drive from June the 22nd. It comes to me in an arrest affidavit that has no bond, but I will be setting the bond today. The public defender is appointed to represent you. The division is 14? 14. What's the state's position with regard to conditions of release?
We asked for a $5,000 bond, no contact with the victim of the child, no unsupervised contact with any children under the age of 18.
The appropriate bond in this case is set by me today at $5,000. No contact with anyone that's named or referred to in the narrative of the arrest affidavit as a victim or witness, and no contact with anyone under the age of 18 years old while the case is pending. Not to be in possession of any weapon, including a firearm. You will want to talk with your attorney about trying to resolve any practical problems that required set of conditions present. I understand that that's often the case, but that's something that you and your attorney will need to discuss, and then the judge assigned to the case may be willing to hold a hearing to try to resolve practical problems. But I cannot do it at first appearances.
I understand.
Good morning, Your Honor. Sorry for interrupting your courtroom.
Thank you.
Creole interpreters on standby.
All right. We'll see if we can move that case forward and hold the first appearance with regard to Cherry Goree. It's case number 2019 MM 5264. He is coming into the courtroom right now, and he'll put on the earphones so that he can hear the Creole interpreter this morning. This is a charge of possession of cannabis less than 20 grams. It's a misdemeanor. It's from 2048 Americana Boulevard from earlier this morning. This is a case that if there is a conviction, it's a loss of driving privileges for a year, as well as whatever the additional sentence might be. The public defender has
Your Honor, can we have pretrial tell us his criminal history, because we don't have it yet, because it's a second session case.
Sure. It's 2 felonies, 3 misdemeanor convictions, no FTAs. Convictions were for resisting officer without violence, possession of cannabis, trespass, aggravated assault with a deadly weapon.
Your Honor, sorry for interrupting. The individual just spoke. Interpreter could not hear. So if possible, closer to a mic will be great.
all right.
Sure. It's 2 felonies, 3 misdemeanors, no failure to appears. Convictions for resisting officer without violence, possession of cannabis, 20 grams, trespass, and aggravated assault with a deadly weapon with intent to kill.
The public defender is appointed to represent Mr. Goree. There may be an offer from the state.
There is no offer, but no objection to ROR at this point.
All right. I would suggest that Mr. Goree talk with his public defender as to whether he feels he would prefer to resolve the case today by entering a plea, or he can be released on his own recognizance if he indicates that he will in fact show up for each and every hearing set later on.
State did not make an offer. There is no offer from the state.
Okay, all right. This will be an ROR then? No. It'll simply be an ROR today. Stay in touch with your attorney so that you know when to come back to court. Your next hearing will be in the downtown courthouse. I'm going to spell his name for the court interpreter. His first name is Tcherry, last name Gouret.
Thank you, Your Honor.
All right. I have one more case that is indication of the need for a Krill interpreter, and it is Evio, E-V-I-O, Antenor, A-N-T-E-N-O-R, case number 2019 CF 8972. This is a charge of battery by strangulation, domestic in nature. That is a felony charge. It comes from June the 22nd at 1081 South Kirkman Road. That is an apartment complex. The victim is listed as Beverline Adolphe. This is a domestic case. It comes to me as no bond, but I will be setting the conditions of release. There is a witness here that will be sworn in.
Please raise your right hand, please. Do you swear her affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name for the record.
Beverline Adolphe.
I do appoint the public defender to represent Mr. Antenor. And the division is TWY, that would be Thomas Young, and that is Division 14. And the defense may inquire of this witness at this time, if you choose to.
You're gonna state inquire?
We'll allow the state to inquire, yeah.
State may inquire.
How do you know Mr. Antenor?
He's my husband.
Are you afraid of him?
No.
Would you like contact with him while this case is pending?
Yes.
Has anything like this happened in the past?
No.
If something happened in the future, would you feel comfortable in calling the police
Yes, ma'am.
or 911?
Yes.
Were drugs or alcohol related to this incident?
No.
Were there any minor children involved?
No.
If the defendant was released without having to post a bond, would you feel comfortable with that?
Yes.
No further questions, Your Honor.
Do you guys live together?
Yes.
Okay. And does the defendant help provide in the paying of the bills?
He's the only one working. I'm not working right now.
Okay, so without his presence in the home, you would be unable to meet?
Yes.
Okay. No further questions, Your Honor.
You understand you said argument.
You can return to the audience. Thank you.
Thank you.
What is the state's position?
State has no objection to PTR, Your Honor. We would just request that it be face-to-face pretrial release. Contact will leave in the discretion of the court. No weapons, no firearms, no drugs or alcohol. We will request that it is face-to-face pretrial and not that he be allowed to report by phone in or mail in.
All right. Is your client willing to accept that as the conditions of release as recommended by the state?
Yes, Your Honor, he is okay with the
All right.
PTR.
In this case, it will be face-to-face pretrial release. No violent or hostile contact is the condition of release. That means that the victim and the defendant will be residing at the same location if they both chose to do so, notwithstanding the fact that it is a felony battery charge by strangulation. That means that all of the responsibility is upon you, Mr. Antonor. If something seems as if a situation occurs that makes it seem to you that either violence or hostile activity might occur, it's your responsibility to leave and make sure it doesn't happen, because the judge in Division 14 would put you back in jail if that judge believes that that has happened. Because most cases of this nature, there would be a high bond. And so because of the testimony given and these allegations, it seems to me that you should have the opportunity to reside at the same location while the case is pending, but it is still an active case. You need to stay in touch with your public defender so that you know when to go to court next. You need to stay in touch with pretrial release so that you know what your obligations are as far as face-to-face pretrial release.
Your Honor, we also want no weapons and firearms.
You're not to be in possession of any weapon, including a firearm, while the case is pending. That concludes the Creel interpreter cases.
Thank,
Melissa Daniels is the next case.
She refused, Your Honor.
I note that she refused when the weekend judge, Maureen Bell, saw this case yesterday, and so I do not reset it again. She is held on a $1,500 bond on a felony petty theft, not to be reset.
And we ask for no return to the scene as well, Your Honor.
So it's $1,500 bond and no return to the location, which was?
I have one moment, Your Honor.
All right.
Macy's on 3505 East Colonial Drive.
Next case is Aaron Dale Howell.
He also refused, Your Honor.
And Mr. Howell is being held without bond because of a prior case. The new case is possession of an anti-shoplifting. And I don't have an application from him. What I am doing today, because he's being held without bond, out of an abundance of caution, I'm appointing the public defender to represent him so that he can be seen, and that appointment is in Division 14. He needs to understand that he is going to be here until he sees a judge because of the prior case. It indicates he was out on bond for possession of meth and other charges in case number 2019 CF 4548. And I rule that he is going to continue to be held until he is seen at first appearances. So I'll reschedule it for tomorrow to see what happens. Michael Zastar, Starney.
Yes.
This is a grand theft third-degree warrant from Division 20. It refers to June the 5th of 2019, so it was from 2 weeks ago, 3 weeks ago. The judge set a bond at $3,500. I've appointed the public defender to represent you in that case. You can now bond out, and there would be a condition that you not return to the location that is alleged to have been where there was alleged to have been a grand theft. But you have the public defender in Division 20.
Excuse me, Judge. I was in a car accident prior to coming in here, a week before everything took place. I have injury in my scalp, I have spinal injury, and I have a cast. And I still have doctor's appointments to go to, and I still have a job. So I'm not trying to lose everything. I don't even remember the crime. I don't have my train of thought. I'm asking for ROR.
Here's the situation. It is the kind of case where I am unable to consider something like that because a circuit judge has reviewed the case and has already made that decision as to the appropriate bond, and I am not to change that. Your next step is to apply to the judge assigned to the case for the relief that you're seeking. I cannot do it at first appearances. Some cases I can, but this case I cannot. Corwin Mathis. This is an arrest affidavit from yesterday at 101 East Central, trespassing in an occupied structure. Misdemeanor charge, the bond's $500, no return. It has to do with it's alleged that there was a manual pulling of a fire alarm at the library. By my review of the case, I set the bond actually at $1,000 today. I note that he is sought by Dade County. However, they do not seek him to be transferred to Dade County from Orange County. But just to note that there is an active warrant for petty theft out of Miami-Dade. You have not requested the public defender. Are you planning to represent yourself? Or do you
How's
think
there a warrant for my arrest in Dade County on petty theft?
do you think it would be best to ask for the public defender today?
I want to talk directly to you.
That would not be appropriate. What my question is, are you planning to proceed without an attorney, or are you going to hire a private attorney, or your third option would be to request a public defender today?
Oh, no, I don't need him.
All right. You can now bond out, no return to the library while this case is pending.
So what does that mean?
That means you can bond out or you can remain in jail. You'll be told when your next hearing is. Randall McCullum. Are you Randall McCullum?
Yes, sir, I am.
All right. This is a case that's been reset. It's a disorderly conduct charge, reset because it was thought by Judge Bell that this might be an opportunity to be resolved, but she would not do that yesterday. The problem that perhaps interferes with that is it is alleged that he's out on bond on another case, a battery charge.
She did not revoke that bond.
Okay. What's the state's position concerning this situation?
May I have one moment, Chair? I'm trying to pull the out on bond case.
Judge Bill took no action on it yesterday.
It's 2019 MM 4939, charge of battery in Division 83. Brenda Sikansky represents him. He bonded out on June the 20th, and his return date was yesterday. I'm
No,
sorry,
actually, I just wanted
I'm
to
sorry,
see-
his return date is July the 23rd.
I wanted to see what our office was doing with the case. Your Honor, we'll do an adjudication and credit for time served.
Okay, you need to consider whether that's in your best interest to resolve the case today.
I would like to resolve it. They did not revoke my bond, and I told her, thank you very much. I didn't know how to plead yesterday because I didn't understand, but I will accept.
You can enter a plea today. What's that? Let me see. No,
Was the public?
pro se.
Was the public offender?
Pro
no?
se.
Pro se.
The charge before me today is disorderly conduct. It is a city ordinance violation, North Orange Blossom Trail and Colonial. Panhandling. How do you plead?
No contest, sir,
Okay.
and thank you.
Did you read and understand your plea form?
Yes, sir, I do.
Okay. I'm very familiar with that intersection. I grew up in that vicinity. It's a very, very dangerous intersection, and part of the reason for this type of charge is to keep you from being run over. Okay, so you need to figure out some other location other than there, because I do see people all the time from there, so I know that intersection is being watched, you know. And there are 5 or 10 in Orange County that are especially dangerous, but that's one of them. The sentence in this case is an adjudication with time served to be released today. It's the 22nd, the 23rd, and the 24th, so it's 3 days credit for 3 days. You'll be released today. I order you not to go back to that location during the next 177 days. Your court costs will go into a civil judgment.
How much will that be, sir? How much will that court cost end up being?
Well,
On
it's
Social
in a
Security?
civil judgment, and the amount is? What? $223. So pay it whenever you can. Yes.
I won't go back there no more, Your Honor. I'm on Social Security and I'm mental health. I just moved here. I'm gonna get off the street on the 1st.
Very good. That's a proper goal. Okay.
Can I ask you a question?
Yes,
Do you
sir.
have maybe a list of, or maybe a phone number where I can speak to some people to get off the streets?
I don't. Perhaps, have you been to the Coalition for the Homeless?
No, sir.
You think that might be a place to start? It's 635 West Central.
I don't know which side I'll try to find. I just lost my mother on the 6th. You know, and I don't even drink or do drugs, but I've been drinking myself to death, grieving.
That would be a place to go, would be the Coalition for the Homeless. There's also a rescue mission on, I believe it's West Washington, about 2 blocks west of the trail. So if you go to about 4 blocks south of where you were in that intersection, and then go 2 blocks west, you'll also go to, you can find that, I believe it's called the Orlando Rescue Mission. Those are 2 places are on West Central to the Coalition for the Homeless. Check those places next. Okay?
Thank you.
Stephen Joseph Dembski. This is an arrest report, and it is from Longwood, which is actually, Longwood is in Seminole County. The case starts at 7022 West Colonial Drive, Home Depot. The charge is a felony theft based upon the amount. The public defender is appointed to represent you in Division 14, and it's case number 19 CF 9020AO. Bond is shown to be $3,000. No return to the Home Depot at 7022 West Colonial Drive. The date of the event that's the subject of the case is June the 19th. No contact with anyone that's described as either a co-defendant or a possible co-defendant. No contact with anyone that's an investigator, a victim, or a witness. The co-defendant might be James Dembski. This is Stephen Dembski. All right? You do have the Public Defender in Division 14.
Yes, sir.
All right, thanks.
This is Abel Gomez. This is an arrest affidavit that has 6 charges: possession of cocaine, possession of heroin, possession of cannabis, misdemeanor level, possession of drug paraphernalia, misdemeanor, possession of heroin again, and introducing contraband into a county facility. So there are 4 felony charges and 2 misdemeanor charges listed, with a total bond of $1,650. These charges come from Bywood Road and Orwood Road. General area, Claricona, Ocoee Road, and Edgewater Drive. So that's, generally speaking, that's a little north of Lee Road, between Lee Road and Seminole County. The public defender is appointed in Division 15. The case is complicated by the fact that he was out on bond on a charge of burglary of a conveyance and petty theft in Division 12, case number 2019 CF 3700 AO. He posted a bond of $8,400 on April the 18th. What is the state's position concerning this case?
I have one moment, Your Honor.
And Your Honor, there was also another case in which he was ROR'd. a first appearance detainer was added for that.
All right.
In the 19 CF 3700 case, the state has not made a charging decision on that case. So state will request no action. So there was another case.
The other case was 2019 MM 004345AO.
In 19 MM 4345, the state has filed, it came in as a burglary of conveyance criminal mischief. The state filed a trespass. I believe the last notes I have is had arraignment on 6/5. I don't have a follow-up on what happened after 6/5 on that case.
Okay. I believe that what I am to do on taking the totality of this into consideration, on the burglary charge for which he was released ROR, no action is taken and the hold is released. On the second case, I do revoke the bond, and there is a new bond in that case. It is $2,000. It will be treated as if he had missed a hearing on a misdemeanor charge first time. Ordinarily, the judge would set a bond at $2,000 for failure to appear, so that's what will be done here. So you can post the $1,650 on the new case and the $2,000 on that prior case to secure your release. Stay in touch with your public defender with regard to all these matters. They're all still active, even though you were ROR'd on the burglary charge. Barkey Muller.
He's not quite ready yet, Your Honor.
Okay, we'll come back to that. Harold Horn.
Mr. Horn is medical.
All right. Mr. Horn will be reset for tomorrow. Roger Johnson.
Yes, sir.
It's a charge of possession of cocaine from Jackson and Ritter Court from last night. The public defenders appointed to represent you in Division 12. Your bond is $1,000. No return to that location and no contact with co-defendant Deasha Pinson while the case is pending. You do have the public defender. So you can post a bond of $1,000, not to be in possession of any substance prohibited by law while the case is pending.
Yes, sir.
Ishmael McDonald King.
Good morning.
This is a driving vehicle charge, but it is charged as a felony. It's driving while license suspended, but it's alleged in the narrative that there are 2 prior convictions, and that would make it a felony if the state can prove that. The arrest comes from Winter Garden Vineland Road and Susette Boulevard. I don't know whether that's Sunset or Susette. Sunset. And it's from yesterday. The public defenders appointed to represent you in Division 22. The bond is $2,500. Additional condition, not to drive unless your driver's license is reinstated before the case is resolved.
And he did qualify for straight PTR, Your Honor.
No objection to PTR.
All right. You'll need to talk with your public defender right now to decide whether you would prefer to post a bond of $2,500 or in lieu of that, be on pretrial release and be responsible to the pre-trial release program.
Yes, Your Honor, he would, PR.
All right. This case will be pre-trial release. You need to be particularly aware of when you have to go to court and where, because the judge will have noted that you were released without having to postpone on a felony charge, and that the judge has become highly interested in you showing up for each and every hearing.
Yes, Your Honor.
Your Honor, this is Mueller.
Juan Luciano.
No, Your Honor, this is Mueller.
Oh, okay, this is Barkey Mueller, or Mueller. This is a case in which Judge Bell yesterday had a first appearance. And at that time, probable cause was not found on the charge of possession of cocaine. And the Office of the State Attorney was given 24 hours to present probable cause facts or supplements.
Yes, Your Honor, I did reach out to the attorney that was covered this weekend. I've not yet to hear back, and I know that private counsel is here for it. However, Your Honor, if I look at Florida Statute 316.610 sub 1, and it says any police officer may at any time upon reasonable cause to believe that a vehicle is unsafe or not equipped as required by law, or that its equipment is not in proper adjustment or repair, require the driver of the vehicle to stop and submit the vehicle to an inspection and such tests with reference thereto as may be appropriate. I believe, based on speaking to counsel, that the Judge Bell did not find PC based on the stop. And our state's argument would be that the crack in the windshield gave the officer probable cause to stop the vehicle. It's listed in, I believe, the third line. He says, the officer says, I observed a blue Audi Florida tag drive past me with a crack in its windshield. And then from there, the officer then found drugs both on the co-defendant, Mr. Washington, and Mr. Mueller, this particular defendant.
Your Honor, Nicole Dickerson for Mr. Mueller. I understand the statute that counsel referenced. However, there's binding Supreme Court precedent that requires officers to have probable cause of a traffic violation. Judge Bell specifically ruled that just the officer seeing a crack in the windshield, and I believe that she bases that on a great number of Florida cases that hold the same thing, that merely seeing a crack in the windshield would be insufficient to give probable cause, even under that statute that counsel quoted, simply because there are requirements under the statute that it affect the vision of the driver, some things like that. We have no description of the crack. We have no supplemental information. I would ask, Judge Bell made a ruling. At this point, the state has no supplemental information, and I would ask that the court not revisit the ruling without additional information.
The choice, my ruling is that there's a choice for the state. I agree with the argument of both sides to this extent. I believe the probable cause does come from a factual allegation that driver safety or ability to drive the vehicle is affected by whatever the incident is. And this narrative doesn't say what is necessary for a judge to make that decision. So the state can ask for more time, or you can simply determine that it's not going to occur, in which case this would be an ROR case.
I can ask the jail, did the judge rule on the out-of-bond cases yesterday?
No, just reset them.
So the state,
So they're still, the hold's still there for them.
I'm sorry?
The hold is still there.
Okay, thank you. So, Your Honor, state will allow for ROR on the current case. However, the defendant is out on bond on two different cases, a duelist and two duels. State will request that those bonds be revoked and at least be doubled on those cases.
I would say that if no probable cause is found on the new case, then there's no basis for taking action on the prior cases, because the only reason for taking action on prior cases is an allegation that, a successful allegation that a new crime was committed while he was out on bond. So
Well, I think-
if you decide to not ask for additional time, he will be able to be released on ROR. That's my ruling today.
Well, my state's argument would be that the allegation of a new crime committed is not the same as no PC for the stop. The allegation is that of violating his conditions of release will be that he possessed cocaine. That is separate an issue of the stop. If the court found that there was no PC of the stop and still possessed the cocaine, he would still be in violation of conditions of the release by committing a new crime. State will request another 24 hours. I can email the officer right now and request that he give me some more information. I reach out to the attorney and he has not yet responded, but obviously it's a downtown attorney in the middle of a morning court session.
And Your Honor, we would object. I don't believe the state is entitled to an additional 24 hours.
The state is entitled to a total of 72 hours, so they've used 24, so I will give the state an additional 24 hours.
Just for the record, is the court finding that the state has shown good cause for that extension?
I'm ruling that the state doesn't have to show that. They have to show that they've been unsuccessful in meeting the requirements set by Judge Bell. And so I am granting that request for an additional 24 hours since they're entitled to it. I believe the state is always entitled up to 72 hours. And the fact that yesterday was a weekend does affect my decision. If this was Tuesday to Wednesday, I would probably rule differently, but I do understand there's a difference in logistics and trying to get these matters accomplished. And so I believe taking all that into consideration, the state is entitled to an additional 24 hours, and I'll see Mr. Mueller again tomorrow morning.
Thank you, Your Honor.
This is Juan Luciano.
Mr. Luciano is mental health director.
Okay, be reset for tomorrow morning. Sonoya Sanders.
Yes, sir.
This is an arrest affidavit from June the 22nd, just before midnight, at 716 West South Street. Count 1 is possession of meth. Count 2, resisting an officer without violence. Bond set at $1,000. Count 2 being a bond of $100, total $1,100. The appellate defender is appointed to represent Mr. Sanders in Division 22. I note that he was out on bond June the 7th. Division 15, case number 2019 CF 6608. Bonds was set at $15,000. He was released on his own recognizance due to the state not filing. On case number 2019 CF 5364, the same occurred. That case is in Division 11. At this time, based upon the new charges from the 22nd, I revoked the bonds on those two prior cases, and he is held without bond till he sees the judge in Division 15 and the judge in Division 11. Brian Thomas. This is an arrest affidavit from yesterday, 902 Lee Road. Count 1, possession of heroin, bond $1,000. Count 2, possession of cannabis less than 20 grams, bond 100. Possession of drug paraphernalia is count 3, bond 100. Total bond $1,200. Public defender represents you in Division 12. No return to the Walmart Neighborhood Market, 902 Lee Road, while this case is pending. Not to be in possession of any substance prohibited by law while the case is pending. Not to be in possession of a weapon, including a firearm, while the case is pending. Freddie Lee Thomas. This is a charge of burglary of an unoccupied dwelling having a bond of $5,000. The public defender is appointed to represent you in Division 20. The case comes from 2875 Carew Avenue. It is a $5,000 bond plus no return to within 500 feet of 2875 Carew Avenue. No contact with anyone that's named or referred to as a victim or witness in this case. Public defender does represent Freddie Thomas in Division 20. There's a complication in the following way. He was out on bond on the charge of grand theft, third degree of a motor vehicle and possession of fentanyl. Division 12, case number 2019 CF 7113. Having posted a total of $5,000 bond on May the 17th. I revoke that bond today. You're held without bond until you see the judge in Division 12. State of Florida, Jared Williams. This is a charge of carrying a concealed firearm. It's a felony charge. Bond is $2,500. It's from Disney Springs, 1486 East Buena Vista Drive, in the vicinity of the STK Steakhouse. It is alleged that the defendant was in possession of a firearm, 2, that it was concealed, and 3, he did not have a concealed carry license. The public defender is appointed to represent you. I'm sorry. There is no request from Jared Williams concerning an attorney. Are you planning to hire a private attorney?
Yes, sir.
All right. Advise your attorney that your bond is $2,500 and your case is in Division 11. And I've ordered you not to return to any portion of some 44,000 acres of Disney, no Disney, while this case is pending.
Yes, sir.
And he did qualify for straight PTR, Your Honor.
After my review of the allegations, I determined that I would not release him other than having posted a bond of $2,500. This is Jesse Lee Butler. It is a city ordinance violation of open container of alcohol at West Church Street in South Terry from yesterday. It's Division A, and it's case number 19 MO 1203. There may be an offer on behalf of the city to resolve this case today at first appearances.
Adjudication 3 days.
Okay. Mr. Butler, I'm going to appoint the public defender to represent you because you're on probation, and that makes this particular case a little bit more complicated than the usual city ordinance violation. And your attorney is standing next to you and would advise you that you should not try to resolve the case until there's been a long discussion with your attorney about the consequences of the situation. You can have a portion of that right now, but ordinarily, you do not try to resolve the case at first appearances if you're on probation, because it will adversely affect your probation, or it could.
Okay, yeah, Your Honor, I informed him of the probation and why he wouldn't want to resolve this case. So, is there a bond on the
$250.
$250? Your Honor, with this situation, being that it is an open container, would you be willing to consider an ROR?
What's the state's position concerning that request?
No objection.
Okay. Yes, I am. This will be an ROR on this case. So I'll write that on there. This is Cynthia Red. The public defender is appointed to represent her on a disorderly conduct charge, a city ordinance violation, case number 19MO 1204. It's at 101 North Roslyn. The case is one where the city may make an offer to resolve the case at first appearances.
Either an ROR or withhold credit for time served.
Okay, talk to your attorney about those options today. Yes.
And, Your Honor, she is going to resolve her case today.
All right. What is your full legal name
Cynthia Renee Red,
and your date of birth?
9/15/70.
All right. And what is your place of birth?
Birmingham, Alabama.
All right. The charge before the court today is disorderly conduct. It was at Lake Eola Park yesterday.
Yes, sir.
How do you plead to that charge?
No contest.
Did you read the narrative of this charge, of this arrest affidavit as to what it says you said?
Yes, sir.
Okay. And can you imagine any situation where you would not be arrested if you yelled that? Okay.
You're correct.
Okay.
I'm very embarrassed. I apologize.
All right. And do you have any questions you want to ask me about this charge?
I don't think so.
Are you satisfied with your attorney?
Yes, sir.
Okay. I'll accept the plea at this time. And the offer was a withhold and time served?
Yes, Your Honor.
Okay. Withhold adjudication. You do not have an adjudication on this case. And it's 2 days, credit for 2 days. You'll be released later on today. I'll order you not to go back to Lake Eola Park during the next 179 days.
Okay. Thank you, sir.
Court costs go into a civil judgment. This is Christina Melton. It has, this arrest affidavit has 2 charges: possession of drug paraphernalia, a state charge, and possession of alcohol on a street, sidewalk, or alleyway, a city ordinance violation. The bond's 500 and 100 for a total of 600. I've appointed the public defender to represent you on those charges. It's at 26th Street and South Lawrence Washington Trail. So that would be right in the vicinity of Cayley and the trail. There may be an offer from the state and the city to resolve this case today.
Adjudication 4 days, Your Honor. Credit
Okay.
for 2.
Talk to your attorney about whether it's better for you to bond out or to enter a plea.
Your Honor, she would like to resolve the case today.
All right. What is your full legal name,
Christina Marie Melton,
date of birth?
8/13/1974.
Okay. There are 2 charges. The first one is possession of drug paraphernalia. How do you plead?
No contest.
Count 2 is possession of alcohol in the open area of the city. How do you plead?
No contest.
Okay. Do you feel that you were under the influence of any substance that makes it difficult for you to make it the appropriate decision today? Okay. You feel fine?
Yes, sir.
Okay. Are you satisfied with your attorney?
Yes, sir.
Did you have enough time to decide what's best for you?
Yes, sir.
Did you read and understand your plea form?
Yes.
Do you have any questions you want to ask me about this case? No questions?
No.
I'll accept the pleas at this time. On each case, it's a sentence of an adjudication, 4 days, credit for 2, running concurrently, that is at the same time. You should be released tomorrow.
Thank you, sir.
But it's very important that you just make a decision. I'm concerned for your health if you are in fact, if you're consuming alcohol and other substances that are illegal. you will find yourself back here over and over again.
Yes.
And that's kind of a goal. I hate to see people over and over again. And usually when I don't see them anymore, it's because they're not around any longer. So it's up to you to make a decision pretty soon. All right?
Yes, sir.
It is one in which you are not to return to that intersection of 26th and South Lawrence Watson Trail during the next 350 days on count 1. And you are to pay the court costs within 350 days from today. You have almost a year to pay the court costs.
Thank you.
John Powelski. This is a charge of disorderly conduct at Central and Lake from yesterday. I've appointed the public defender to represent you in Division A. It's case number 19-MO-1206. There's a second arrest affidavit. Count 1, assault on a law enforcement officer. Count 2, resisting without violence. I find that the assault is the main case. It has a bond of $500. Resisting is $100. And on that second arrest affidavit, the bond is set by me as $100. So your total bond is $700 for those 3 different charges. Public defender represents you in Division A on those cases. And I am not intending to try to entertain a resolution of the case today. Stay in touch with your attorney, and you must bond out and have no contact with anyone that's named or referred to in the case. And you're not to return to Lake Eola Park while the case is pending.
So am I understanding you correctly, Your Honor? I'm not allowed to have contact with Miss Red?
Hold on.
It's my fiance. She just came before you 2 cases ago.
Hold on. Let me take a look at both of the affidavits.
She resolved her case, Your Honor, with a plea. She also had a no return order.
Okay. I will specifically indicate that you can have contact with Cynthia Red.
Okay, thank you.
If she chooses to do so.
Yes, sir.
All right. Diasha Diamond Pinson?
Yes.
This is an arrest affidavit from yesterday at Jackson and Ritter Court. The co-defendant was Roger Johnson, who I've already seen. Possession of cannabis is the first charge of misdemeanor, and providing false identification is a misdemeanor. The appropriate bond is $500 on count 2 and $100 on count 1 for a total of $600. The public defender is appointed to represent you. The state attorney may have an offer to resolve this case at first appearances.
Yes, Your Honor. No objection to an ROR, or count 1, a withhold, count 2, adjudication, 3 days in jail with credit for 2.
Okay. You should talk with your attorney, the public defender who's standing next to you, as to what is better for you. It's either enter a plea or there's no objection to an ROR, and then you would go to downtown court for an arraignment at a later date.
Your Honor, she does want to resolve the case this morning.
All right. The offer was a withhold on count 1 with an adjudication on count 2, and what were the days offered?
3 days, Your Honor.
Thank you. What is your full legal name
Deasha Diamond Benson,
and your date of birth?
02/17/1994.
Thank you. Count 1 is a charge of possession of cannabis less than 20 grams. How do you plead?
No contest.
Count 2, possession, providing false identification. How do you plead?
Guilty. No contest.
Did you have enough time to talk with your attorney about your options today?
Yes.
Are you satisfied with the services rendered to you by the Office of the Public Defender?
Yes.
Did you read and understand your plea form?
Yes, I did.
Do you have any questions you want to ask me about these charges, the facts of the case, the plea that you're in, or the proposed sentence?
No. No.
Okay. I accept the pleas at this time. It's a withhold of adjudication on count 1. That's so that you don't lose your driving privileges if you have a driver's license.
Okay.
Count 2 is an adjudication, though, so you have a criminal conviction on count 2. The sentence on count 1 and count 2, each one is 3 days, credit for 2, running concurrently, that is at the same time. I believe that under this sentence, you'll be released later on this afternoon, generally
I got.
speaking.
Oh, okay, never mind.
Hold on. Now, you do have court costs in this case. You have 350 days from today to pay your court costs. I also order that you not return to the intersection of Jackson and Ritter Court while the case is pending. You're not to be in possession of any substance prohibited by law during the next 350 days on count 1.
Okay.
David Harold Allen.
Mr. Allen refused to attend, Your Honor.
All right. That's his second refusal, so I'm not going to reschedule his. And he's held on a no bond for escape, so it doesn't really affect him, but his next hearing will be an arraignment. Christopher Day,
Mental health.
reset for tomorrow. Clifford Gray.
Yes, sir.
You're held on a felony charge. The title of the charge is possession of cocaine. It's from 39th Street and South Orange Blossom Trail. That's the intersection where there's a traffic light just south of I-4.
Yes, sir.
Your bond has been set at $1,000, and I don't have an application from you, but I'm suggesting that you would best be served by having an attorney. Would you like the public defender to assist you in your case? And I want you to confine your answer to that question. Do you want an attorney? If you cannot afford an attorney, I will appoint the public defender to represent you.
Yes.
I believe that you would qualify for the public defender if you ask for one. Let me ask you a couple of questions. Do you have a permanent job right now?
Sir, I ain't worked in about 30 years.
Okay. And what's the source of your income? In other words, do you live with family?
Yes, sir.
Okay. I appoint the public defender to represent you at this time. It's in the division for John Marshall, no, it's JMD. Who would that be? Number? Division 12. The public defender represents you in that division, and your bond is set by me today at $500. It is a felony charge of possession of cocaine.
So what happened to me, then I don't know nothing about it at all by being nothing by being by 60.
That's why I have appointed a public defender to represent you, to assist you, and that person can advise you concerning your case. The next case is LaDacia Washington.
She's behavior, Your Honor.
Okay. Yesterday, Judge Bell found that she refused, so this case will not be reset again. She can bond out on a $1,250 bond for 3 different charges, including, and they are misdemeanor charges. I do find that I'm going to change the bond in the meantime. The appropriate bond for Ms. Washington, count 1 is $500, count 2 is $100, and count 3 is $100, for a total of $700. So at this time, the total bond for her is $700, but I'm not going to reschedule a first appearance anymore since she has refused twice. And there's an active warrant from Osceola County as well. And there's a violation of probation for her, and that is Osceola County. So she's actually not able to get out in any event. So that's where we are. I believe that concludes session 1. Do we have 33-day motions today here?
They were in court 2 this morning.
Very good, thank you. We will be doing interpreter cases this afternoon or next. How long would you like to take for recess before, or when are those interpreter cases scheduled for, what time?
They're DVs, so they were told at 1.
We will set them as far as time?
Well, they were DVs, they're misdemeanor domestic violences, so they were told, the victims were told to be here at 1 or 12 o'clock.
Here's my question, for the victims, did any indicate they were coming?
I don't know, I don't have the second session paperwork with me, I have to.
Right now, it's 10:45. Do we also have cases that are not domestic for the afternoon?
Yes, Your Honor.
So we could resume at a time that would give us some time to do non-domestic, and then assume that we would proceed at 12:15 with domestic cases?
So you said, can we do 11? 11:30?
What time is Spanish?
She's saying they're DV cases, so they're told to come at 1. The victims are told to show up at 12.
Yeah, so can we
At
do
12.
11:30?
So 12:30 for the.
No, I'm saying, can we start at 11:30 the second session, and then we'll
All
roll
right.
through till.
Okay, we'll return then in 45 minutes.
Okay, Your Honor.
Thank you, Anna.
This is the second session in courtroom 1 for Monday, June 24th, 2019. Judge Kirkland presiding. The first case from this group is Donald Thomas Blackstock. This is an arrest affidavit from last night at 6000 Universal Boulevard, which is the Hard Rock Cafe. There are 5 charges. disorderly intoxication, resisting an officer with violence. Count 3 is battery on a law enforcement officer and has a bond of $2,500. The fourth charge is battery on a uniformed licensed security officer, and count 5 is trespass in a structure, refusal to leave. The appropriate bonds as set by me today, count 1 is 100, count 2 is 150, count 3 is 2,500, count 4 is 150, count 5 is 100. Therefore, the total bond will be $3,000 for the 5 charges, total $3,000. The public defender is appointed to represent Mr. Blackstock in Division 17. There will be a condition to have no contact with anyone that's named as a victim or witness. No return to the Hard Rock Cafe, 6000 University Boulevard while the case is pending. Not to be in possession of any weapon, including a firearm, while the case is pending. Next case is Jason Fernandez. This is an arrest affidavit from last night, a little before midnight, at 1433 Rovida Circle. It's a felony charge of attempted burglary of a dwelling, bond set at $1,000. I have appointed the public defender to represent you in Division 10. The case is complicated by the following. It is indicated here that you had secured your release May the 10th, 2019 on the charge of burglary of a conveyance, grand theft, third degree, and petty theft with 2 prior convictions. It was a ROR due to the likely event of the state not filing within the first 33 days. That case number is 2019 CF 4951. At this time, I revoke the release in that case in Division 17, and you are held without bond until you see the judge in Division 17. The conditions of release on the new charge are as follows. It's a bond of $1,000, no return to 1433 Rovida Circle, and no contact with anyone that's named as a victim, witness, or animal of victim or witness.
And then, Your Honor, I'm showing that there's a second out on bond case, a 2019 CF 004899 AO.
And does it indicate the type of charge?
An attempted burglary of a conveyance?
And does it have a division?
Looks like 17.
That was a 4/8 arrest. April the 8th arrest.
So it's simply a second affidavit for the same arrest, it appears, because that's the date of the arrest on the burglary of a conveyance, grand theft, and petty theft I just referred to in 2019 CF 4951. So I will revoke the release in that case as well with a no bond. Mr. Fernandez will have to see the judge in Division 17 on each of those matters. The next case is Jaylyn Shirley Holloway. It is an arrest warrant, and it refers to a date of June the 6th, 2019. So it is from 3 weeks ago. The charges are two. The first charge, aggravated abuse of an elderly or disabled adult. No bond. And count two, felony battery, no bond. The judge marked may be modified by first appearance judge. The state may be heard at this time as with regard to the issue of the appropriate bond for the new charge. I will note that the person before me was out on bond on case number 2018 CF
That case appears to be
13660.
closed, Your Honor.
Case was closed, Your Honor,
All
on
right.
the 20th, so Friday. Perfect. Your Honor, we'd ask for a $7,500 bond as to count one. No objection to 150 as to count two. No contact with the victim. Maintain separate residences. No weapons, no firearms, no drugs, no alcohol. The reason why we ask for the $7,500 bond is obviously these are two batteries within a very short amount of time, and these are two different victims.
At this time, I do find that the appropriate conditions of release on this warrant arrest affidavit. For count one, the bond will be $7,500. Count two will be a bond of $150, the total being $76.50. No contact with anyone named or referred to as a victim or witness, not to be in possession of any substance prohibited by law, not to be in possession of any weapon, including a firearm. Also, maintain a separate residence from anyone that's named or referred to as a victim or a witness. I don't know whether there are any such mutual residences, but just in the event that there is, I am ordering that there be separate residences. The next case is Wendy Howard. Thank you. Charles Melvin McGee.
Yes, sir.
This is an arrest affidavit from yesterday, a little before midnight at Lancaster and South Orange Blossom Trail. Count one is possession of cocaine, having a bond of $1,000. Count two, a misdemeanor charge of possession of drug paraphernalia, having a bond of $100. So your total bond is $1,100. I've appointed the public defender to represent you in Division 19. I order that you not return to that location of Lancaster and the Trail. While the case is pending, you're not to be in possession of any substance prohibited by law. The case is complicated by the fact that it indicates that you were out on bond on a charge of aggravated battery. What is the state's position concerning that prior case?
I have one moment, Your Honor. On the out on battery was a 512 arrest. The state has not made a decision in that case. We'll leave that in the court's discretion.
The prior case is a highly viewed felony charge. However, the new charges are not, and so I take no action on the prior case, and there's no longer, I do lift the hold on the prior case. And I believe that what I will do is on the new case, on the possession of cocaine, I believe that the bond should be doubled. It will be $2,000. And the count of paraphernalia will be a 100 for a total of 2,100, and no action taken on the aggravated battery charge. You do have the public defender. This is not, the next case I have is Jocelyn Turner. Thank you. Justin Carlos Lopez.
Yes, sir.
This is a Florida uniform traffic citation involving driving while under the influence. It has resulted in an arrest affidavit. It comes from Sidell Road and State Road 429. It is a misdemeanor charge, and the bond is $500. I do find that there's probable cause to hold you on that $500 bond. You can now bond out. Are you planning to hire a private attorney?
Yes.
Okay.
And he did qualify for straight PTR, Your Honor.
What I'd like to do you have his driving record?
He did not have one. I wasn't able to find one on David.
All right. I am going to require that you post a $500 bond. Make sure that you understand when you have to return for your next hearing.
Yes, sir.
All right. This is Zachary Gordon Van Norman.
Yes, sir, Your Honor.
It's a charge of resisting an officer without violence, which is a misdemeanor charge, from 1201 North Cimarron Boulevard. It's a 7-Eleven store. I've appointed the public defender to represent you in Division A. And the question next is whether the state is making an offer at first appearances on this charge.
Either no objection to PTR or adjudication 3 days.
Okay. Talk to your attorney about that option that you have. One choice would be you resolve the case and you enter a plea. The sentence would be adjudication 3 days, credit for 2. So you get out later on this afternoon. On the other hand, if you feel it would be best to contest the case, you can bond out. The bond's $500. And the option has been given that if you decide to contest the case, you can be released on ROR as far as the state is concerned. So talk it over with your attorney.
Sir. He's gonna accept the state's offer.
Thank you, Your Honor.
State your full legal name
Zachary Gordon Van Norman, sir.
and your date of birth.
5/16/1990.
And when you give your name for various things. Is there a space between Van and Norman in your name
Yes, sir.
ordinarily?
Yes, sir.
Okay. It probably makes no difference. It just indicates here it's run together as if it's one word, but actually you have a two-word last name.
Yes, sir.
All right. The charge that's before me today is resisting an officer without violence from yesterday at the 7-11-1201 North Cimarron. How do you plead?
No contest, Your Honor.
Did you read and understand your plea form?
Yes, sir.
Any questions for me concerning this case?
I think that's it.
Are you satisfied with your attorney?
Yes, sir.
Did you have enough time to decide what's best for you? The choice being a bond out or enter a plea?
Right, he explained it to me, I understand.
All right.
Yes, sir.
I'll accept the plea at this time. You're adjudicated guilty of resisting an officer without violence. And the offer was 3 credit for 2?
Yes, Your Honor.
Okay. It's 3 days credit for 2. You'll be released later on today, but I'll order you not to go back to that 7-Eleven at 1201 North Cimarron Boulevard. No return during the next 350 days. And you have the same 350 days to pay the court costs.
Yes, sir. Thank you, Your Honor.
Job Antonio Perez. This is a warrant that comes from Seminole County, the next county north of here. They seek your return there according to this paperwork for a traffic charge. It was fair to appear for arraignment on a driving while license suspended or revoked. It indicates it's Judge Collins. And so if you have no Orange County cases, they'll pick you up and take you to the criminal court building in South Seminole. Or if you decide to bond out, you can bond out here for $5,000 bond, it says, and just report yourself for whenever the next hearing is. But if you think that that's not the best thing, they'll come and pick you up. And they're supposed to pick you up within 24 hours. Hugo Alejandro Gonzalez Colon.
He bonded, Your Honor.
Joseph Arthur Johnson Jr.
Yes, sir.
This is a charge of disorderly conduct. It comes from yesterday, just before midnight at Colonial and Orange Blossom Trail, also known as Highway 50 and 441. It's a city ordinance violation, and it's for walking and kneeling in the middle of traffic, panhandling for money in that intersection. The public defender is appointed to represent you in case number 19-MO-1208. And there may be an offer by the city or on behalf of the city to resolve the case today.
And one moment, Your Honor. I'm just trying to see his last case. Looks like he pled to another disorderly for 2 days on 5/26. So state will make a 5-day offer.
Talk it over with your attorney as to the public defender standing next to you as to whether it's better for you to try to bond out. The bond's $250. Or if you enter a plea, it'll be 5 days, credit for 2. Today is Monday. You'll get out on Wednesday if you enter a plea. Or tomorrow. I'm not sure which it is.
And Your Honor, he is going to accept the state's offer.
What is your full legal name
Joseph Arthur Johnson Jr.
and your date of birth?
1/1/75.
All right. How do you plead to the city ordinance violation of disorderly conduct?
No contest.
Did you read and understand your plea form?
Yes, sir.
Have any questions for me about this case?
No, sir.
And since you've been convicted before, you're well aware of how that law works. And it's partially for your protection because people get run over all the time at that intersection particularly. I accept the plea, and you're satisfied with your attorney?
Yes, sir.
It's an adjudication, 5 days, credit for 2. No return to that intersection during the next 179 days. And the court cost will go into a civil judgment.
Thank you.